The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good afternoon. Our last case today is McGuire versus Lord Corporation, and we will hear from the appellant.
Good afternoon, Mr. Chief Justice and Associate Justices, and may it please the court. My name is Scotty Forbes Lee, and I represent the appellant in this case, Robert McGuire. I would like to reserve 5 minutes for rebuttal, please. In this case, Mr. McGuire, a sophisticated investor and owner in Lord, wanted to sell some of his shares in the company and then repurchase those shares. He asked the designated liaison between Lord and its owners, Denise Austin, if it would be possible for him to do so. A question about what the business was considering about its stock program, not about what the plan documents said. Ms. Austin responded that Mr. McGuire could sell some of his shares and then repurchase those shares that June. Just 10 days later, Lord suspended its stock program and later terminated it, preventing Mr. McGuire from ever repurchasing his shares. In his complaint, Mr. McGuire alleged that when he sold his shares in Lord, he relied on Ms. Austin's statement that he could repurchase those shares in June, that Ms. Austin knew or should have known at the time of her statement that the stock program would be terminated, and that he suffered damages. Under North Carolina law, these allegations do state a claim for negligence, negligent misrepresentation, and violations of the North Carolina Securities Act. Given this background, the business court erred in two main ways when it dismissed Mr. McGuire's tort claims. First, the business court made an inference about the meaning of Mr. McGuire's email that it was not entitled to make. The court inferred that Mr. McGuire was asking about the terms of the stock program rather than the status of what Lord was considering about the program. The business court drew this inference against Mr. McGuire instead of liberally construing the complaint in his favor, as it was required to do on a Rule 12b6 motion. Second, the business court narrowly construed the allegations in the complaint. The construction created, in essence, a heightened pleading standard beyond what is required by North Carolina law. At every turn at which the business court was confronted with the construction of Mr. McGuire's complaint, it drew every inference against Mr. McGuire and in favor of Lord. We respectfully request that the court reverse the dismissal of Mr. McGuire's tort claims. First, the business court made an improper inference about the meaning of Mr. McGuire's email. For over half a century, North Carolina has required that when courts analyze a complaint under Rule 12b6, every inference must be drawn in favor of the plaintiff. Here, when the business court tested the sufficiency of Mr. McGuire's claims, it focused on the context of Mr. McGuire's email to Ms. Austin. At this point, the court had two paths to follow. First, it could have inferred that Mr. McGuire was asking Ms. Austin to remind him of the express terms of the stock program, or it could have inferred that Mr. McGuire was asking about the current status of the stock program. The business court chose the first path. It inferred that Mr. McGuire was asking Ms. Austin to remind him of the express terms of the stock program. By doing so, though, the business court drew an inference that was adverse to Mr. McGuire. Contrary to the business court's inference in Lord's arguments, this is not a case where one party failed to remind the other of the express terms of the contract. Construing the complaint in the email exchange in the light most favorable to Mr. McGuire supports an inference that Mr. McGuire was asking about the status of the stock program, what the business was considering about the program. Indeed, Mr. McGuire alleged in paragraph 48 of his complaint, that's on record page 12, that he viewed Ms. Austin's response to his inquiry as a clarification on the plan documents available to him. He also alleged in paragraph 30 of the complaint, record page 10, that less than a month before his inquiry, Lord's board had indicated that it was inclined to change the plan. This is all the more reason for Mr. McGuire to inquire whether Lord intended to act on that inclination to change the plan in a way that would impact Mr. McGuire's ability to repurchase his shares. Because of the inference that the business court made about the meaning of Mr. McGuire's email inquiry, the court dismissed Mr. McGuire's tort claims. It deemed Mr. McGuire's reliance on Ms. Austin's response unjustified as a matter of law and concluded that Mr. McGuire could have discovered the answer to his question by reading the plan documents. Importantly, though, as this court explained in Marcus Brothers Textiles v. Price Waterhouse, justifiable reliance is a question for the jury unless the facts are so clear as to permit only one conclusion. That is simply not the case here. Under the inference drawn in the light most favorable to Mr. McGuire, that Mr. McGuire was inquiring about the status of the stock program, Mr. McGuire's reliance was not unjustified as a matter of law. To be sure, Mr. McGuire knew that the stock program was subject to change at any time. He alleged that Ms. Austin was specifically designated by Lord as the liaison between the company and its owners to answer questions about that program. Given this background, it was not unjustified as a matter of law for Mr. McGuire to inquire about the status of the stock program to the person specifically designated to answer questions about that program and to rely on that person's answer to his question. Likewise, reading the plan documents wouldn't have answered Mr. McGuire's question. The plan documents say merely that the Compensation Committee of Lord's Board shall have the full and complete discretionary authority to change the terms of the program, including but not limited to terminating the program. Thus, referencing the plan documents would have told Mr. McGuire what he already knew, that the stock program was subject to change. That's precisely why he further inquired by going to the person that Lord designated to answer questions about the stock program.
If that were his intent, why did he not say, are there future plans with regard to the program? Or I understand that the plan can be terminated at any time. Can you give me any insight with regard to what those plans may be?
Yeah. Justice Newby, the email could be interpreted in one or two ways. It is not a model of clarity, but Mr. McGuire was asking whether it would be possible to resell his shares. He gave a specific window, and that was in June. The email was sent in March. The business court could have interpreted that email in one of two ways, that he was asking merely about the status of the program, merely about the terms of the program, I should say, or about what the business was considering. Construed, though, in the light most favorable to Mr. McGuire, as the court must do on a Rule 12b6 motion, the more reasonable inquiry is that he, as a sophisticated investor, was asking whether the board had any plans to change its program as it was allowed to do in the stock documents, which he was familiar with.
At this point, Ms. Lee, is it a question of what's the most reasonable ruling, or whether a reasonable jury could infer that the plaintiff meant what you have described as the more reasonable interpretation?
Here, since we are at the pleading stage on a Rule 12b6 motion, there are two inferences that could be drawn. The court has to draw the inference that's in favor of the plaintiff, not adverse to him. Here, the inference drawn in favor of Mr. McGuire would be that he was asking merely about what the business was considering about the stock programs. On that inference, Mr. McGuire states a claim for negligent misrepresentations and violations of the Securities Act.
Isn't there actually another way that could be seen as well? You say that there are two, counsel, as to an inference as to the status of the program, or whether or not there was a consideration to terminate the program. Couldn't it also be deemed that your client was seeking some guidance in the interpretation of the program at the time that the inquiry was stated by him, because he put some specific time frames in there concerning his consideration of selling some stock in March or April, and then could he turn around and buy back again in June? While you say that he may certainly have understood the program, couldn't he have been asking just as well, as the business court saw, for an interpretation to plug in, if you will, the specifics that he was contemplating into the program itself?
That's certainly a possibility, Justice Morgan, and I think that goes to my point that there are multiple ways this email inquiry could have been interpreted. Here, the business court simply interpreted it in the most adverse way to Mr. McGuire rather than in his favor.
Well, on the face of it, why you say that there are these multiple ways in which it could be seen, in looking at a 12B6 failure to state a claim upon which relief can be granted, isn't the tact that the trial court took one that this court presently can find was appropriate?
It could find that the business court made one inference about the meaning of the email inquiry, but there were multiple inferences that could be drawn about the email inquiry, and that's why the court erred when it made the inference that it did at this stage. Second, the business court's construction of the complaint created, in essence, a heightened pleading standard for Mr. McGuire's claims. As we discussed in depth in our briefs, a negligence claim must satisfy Rule 8A's notice pleading standard, and claims for negligent misrepresentation and Securities Act violations must be pleaded with particularity under Rule 9B. As this court explained in Terry v. Terry, a plaintiff satisfies Rule 9B by alleging the who, what, when, and where of the alleged misrepresentation. In paragraph 34 of the business court's opinion, that's on record page 120, however, the business court imposes an even higher requirement. For the Securities Act claim, Mr. McGuire alleged that Ms. Austin made an untrue statement of fact that she knew or should have known at the time of Mr. McGuire's March 2nd inquiry that Lord had already decided to suspend or terminate the plan. The business court concluded that Mr. McGuire's allegation failed to state a claim under the Securities Act because he did not specifically allege that Lord had decided at the time of Ms. Austin's email that any plan suspension or termination would occur prior to June 2017. But that timing was implied in Mr. McGuire's inquiry when he specifically asked about his ability to repurchase his shares in June. For purposes of Rule 9B, Mr. McGuire was required only to allege the who, what, when, and where of the alleged misrepresentation. He did that in his complaint. To be sure, he alleged the identity of the person who made the misrepresentation, Ms. Austin. He alleged the content of the alleged misrepresentation, that Mr. McGuire would be able to repurchase his shares in June 2017. He alleged the place of the misrepresentation, the March 2nd email, and he alleged the time of the misrepresentation, March 2nd, and that Ms. Austin knew before that date that Lord had decided to suspend or terminate the stock program. And in any event, Ms. Austin's failure to disclose that Lord had decided to terminate the stock program, or even that it was actively considering terminating the program, states a claim for violations of the Securities Act based on Ms. Austin's omission of a material fact that Lord had a duty to disclose. This imposition of a heightened pleading requirement is just another example where the business court construed the complaint against rather than in favor of Mr. McGuire. That construction is improper under Rule 12B6. Finally, Lord's and Mr. McGuire's briefs discuss the business court's treatment of the negligence and negligent misrepresentation claims as one and the same.
Before you do that, let me ask you a question about the email you were just talking about.
Yes.
The one from March the 2nd. It's reprinted in the business court order at paragraph 17.
Right.
And I'm just wondering if you can explain how that email could be interpreted in the light most favorable to your client, which is, I think, what you're asking.
Correct.
What should have done?
Yeah. So one inference would be, from reading the complaint in context, that Mr. McGuire was a sophisticated investor with access to the plan documents. He even said in paragraph 47, that's on record page 12, that Ms. Austin's response appeared to clarify what the plan said. So the fact that he was a sophisticated investor with access to the plan documents, the documents provide that the stock program can be suspended or terminated at the board's discretion. It's a reasonable inference that Mr. McGuire would reach out to Ms. Austin, who Lord specifically designated as the liaison between the owners of the company and the company, to ask questions about what the board was considering about the stock program. Mr. McGuire was asking if he would be able to repurchase shares in June if he sold them in March. So drawing an inference in the light most favorable to Mr. McGuire would be that he was asking merely if he would be able to do that if the board was in fact considering any changes to its plan at the time of his inquiry.
Okay, thank you.
So moving back to the business court's treatment of the negligence and negligent misrepresentation claims as one and the same, I just want to add one point of clarification on that issue. While it's true that Mr. McGuire's negligence claim is based in part on Ms. Austin's misrepresentations about the status of the stock program, there is also a conduct aspect that makes the negligence claim a little bit broader than the negligent misrepresentation claim. In paragraph 31 of the complaint on record page 10, we allege that Ms. Austin omitted information in her response to Mr. McGuire, or that she knew or with the exercise of reasonable care could have learned by virtue of her work with the board of directors. That conduct-based component makes the negligence claim slightly broader than the negligent misrepresentation claim.
Tell me how that's conduct as compared to just another way of saying they didn't tell me.
Justice Irvin, it's that failure to act. So we allege that she knew or that she knew.
Isn't a failure to act in this context essentially a misrepresentation by omission?
It could be seen that way, but it could also you could also say that it's more conduct based. So she failed.
Yeah, tell me how it's more than just a failure to make a representation and somehow becomes conduct based.
The misrepresentation is based on the allegation that she knew, but if she didn't know, she should have exercised reasonable care to know. She should have sought out that information if she didn't know. So that's sort of what makes the negligence claim also conduct based.
I mean, there may be one, I'm just not coming up with it off the top of my head. Is there one thing that occurred to me might possibly be that you could recognize a negligent misrepresentation claim, but you can't recognize a separate negligence claim based upon the same misrepresentation by omission or commission. Can you cite me to any case that involves a negligence claim of that type that was essentially based on the same, act of omission or commission involving failing to tell somebody something that supported both a negligence claim and a negligent misrepresentation claim? I apologize for not stating that more clearly. I hope the points
Yeah.
clear.
Frankly, Justice Irvin, I cannot point you to a specific case. That's just, when analyzing the two claims, that's one thing that, sort of stuck out as making the negligence claim broader than the negligent misrepresentation claim, just sort of that duty to exercise reasonable care that she could have learned by virtue of her work with the board of directors.
But assuming that we are not persuaded by that particular part of your argument, is there a separate negligence claim apart from a negligent misrepresentation claim in this case?
Under that scenario, no, there is not.
Okay, thank you.
Yes. In conclusion, here, Mr. McGuire pleaded claims for negligence, negligent misrepresentation, and violations of the North Carolina Securities Act. Mr. McGuire respectfully requests that the court reverse the business court's dismissal of those claims. If the court has no further questions, I will reserve the remainder of my time for rebuttal. Thank you.
Thank you, counsel. We'll hear from the appellee.
May it please the court. Honorable Chief Justice, Associate Justices, Your Honors, my name is Charles Rennell with the law firm of Parker, Poe, Adams, and Bernstein here in Raleigh for the defendant appellee, Lord Corporation. Your Honors, Judge Bledsoe's decision to grant Lord's motion to dismiss at the business court was correct and well-reasoned under settled principles of North Carolina law, and we request today that the decision be affirmed. In this appeal, Mr. McGuire asks the court to override the express terms of the stock purchase agreement and to excuse his failure to read that agreement. No principle of law is more basic than this. A party must read the contracts he signs. And whether we view this case as a securities fraud case, or a negligent misrepresentation case or an ordinary negligence case, the result here is the same. Judge Bledsoe ruled correctly following bedrock principles of contract, tort, and securities law, and Mr. McGuire should be held to the terms of the contract he signed. I'll just touch on a couple of brief points about the facts and then move to these settled principles, these bedrock principles of law, and set the table with 4 facts. 1, Mr. McGuire was a senior executive, director of Lord Corporation's Japan operations, and was a sophisticated investor. He was a party to the stock purchase agreement, which was a binding contract that said exactly what his rights were with regard to buying and selling stock. Number 3, the stock purchase agreement made crystal clear that the compensation committee of Lord's board of directors had the sole discretion to amend, modify, suspend, or terminate the agreement at any time. Stated differently, had Mr. McGuire reviewed the agreement, he would have seen that Ms. Denise Austin could not have guaranteed that there would not be a change to the plan because the plan itself makes clear that there is discretion. Number 4, Mr. McGuire alleges in paragraph 48 of the complaint that the plan documents were available to him. And significantly for this case, stated differently, he does not claim that Lord Corporation concealed these documents from him or that he did not have a chance to review them. And so turning now to the claims here, and there are 3 of them, each of these claims was properly dismissed for similar overlapping reasons. On a motion to dismiss, as your honors have already observed in this discussion today, it is essential to review the actual allegations that are pleaded in the complaint. That is the only way to measure whether a claim has been stated. In this case, I will refer the court to a couple of provisions that are 2 different formulations for the theory that is actually pleaded. Again, we're bound to the allegations pleaded, not what the parties may have argued in their briefs. In paragraph 51 of the complaint, the first formulation of the theory appears. And in that paragraph, Mr. McGuire alleges that Ms. Austin, quote, misrepresented plan language. As a threshold matter, there is no such claim as misrepresentation of the terms of a contract because a party under the law has a duty to review the terms of the contract that he signs. Simply put, a party cannot escape responsibility to review contract language. For example, if Ms. Austin had said this, if she had said to him, the plan cannot be changed, your right to buy back shares is absolute. That would have been a false statement to be sure, but it would not be actionable because Mr. McGuire had access to the agreement and a duty to read it, and the law of contracts, tort, and securities law does not protect a party who chooses not to read or follow the documents. In terms of the second formulation of the theory here, again, we are bound, Mr. McGuire is bound to the language included in his complaint. And the second crucial allegation is the omission theory, that Lord failed to remind Mr. McGuire of the language in his stock purchase agreement. And the entire case unravels based on that premise. And Mr. McGuire mentions this theory in 2 different places in the complaint. And I'll refer to paragraphs 63 and 64, which is record page 15. Again, he cannot escape the allegations in the complaint. He claims there that Ms. Denise Austin's communication that McGuire could repurchase shares was misleading because she omitted the material fact. And I'll pause there. When we're looking at a misrepresentation case, we have to see what is alleged to have been misrepresented. And whether it's negligent misrepresentation or securities fraud, it's a question of what the material fact was. Here's what Mr. McGuire says the material fact was. He says, she omitted that plaintiff's ability to purchase shares was not absolute, but rather contingent on defendants not exercising its unilateral right to change the terms of the plan. And in the next paragraph, paragraph 64, he says that Ms. Austin knew that the plan could change at any time, and thus a shareholder's ability to purchase was never guaranteed. So the operative language in the complaint is based on a guarantee that she is alleged to have given. But if Mr. McGuire had simply read the agreement, he would see that was a guarantee that she did not have authority to ever make. So I want to turn now from framing the issue in terms of the allegations to talking about these bedrock legal principles which have been settled for many, many years. Again, the theory here is Ms. Austin's statements created a guarantee, and the word guarantee is mentioned over and over again in the complaint. But the plan documents make clear there could be no guarantee. But settled principle number one is this: a party must read the contracts to which he is a party, and he is bound by the contract terms that he signs, whether he decides to read a contract or not. And stated differently, there is no duty, as our case law makes clear, to remind a party of a contract's terms. Second, bedrock principle: a party cannot satisfy the reasonable reliance element where he could have discovered the omitted facts simply by reading the contract. And third, bedrock principle, and this goes to the point that Justice Ervin was asking about a moment ago, and I do have a case for you, Justice Ervin, in just a moment. A party cannot avoid the elements of a negligent misrepresentation claim simply by calling it a negligence claim. That is, one cannot say a negligently omitted statement can constitute ordinary negligence if it does not constitute negligent misrepresentation. If that were the case, there would not be a claim known as negligent misrepresentation, and no one would ever assert it, because there are all sorts of additional defenses that would apply in that instance. And once more, we will need to look closely at the language that is actually alleged in the complaint to determine whether there is a valid claim alleged there. I want to turn, before we turn to each individual claim, and I want to give just a moment of attention to each claim, but I submit that the same principles will apply regardless of the claim, although the case law cited is a little bit different because it's in a different context. But the policy here is also important, and I want to make sure that I'm clear on this point. If the court were to reverse Judge Bledsoe's decision, we would be on perilous ground in a couple of different ways. It would upend several lines of precedent here regarding North Carolina securities contract and tort law. It would excuse a party from reading contracts and would cast uncertainty as to contractual obligations. The law must provide certainty regarding contracts and obligations of parties under contracts, and we believe that's what Judge Bledsoe recognized here. A second point about the policy is that this is a securities case. It's a securities fraud case. To hold that this claim survives would completely alter the framework of securities transactions, and I think I need to explain that. If Ms. Austin's communication, without reminding Mr. McGuire to read the plan documents, could state a claim, every communication from a company regarding securities would have to be accompanied by a litany of additional disclosures. For example, Ms. Austin would have had to say something like, please refer to your plan documents for all your investment decisions, or please remember that the board has discretion to terminate the plan at any time. And the list would go on. And so every email, and again, it's important to recognize this was an email communication, would have to have paragraphs of boilerplate disclosures. But under the securities laws of North Carolina, indeed under the federal securities laws, that sort of disclosure is not required. And so Mr. McGuire here seeks to create a new duty out of whole cloth in a way that would raise all sorts of practical problems as well. For instance, if Lord were required to tell Mr. McGuire that it's, as alleged in paragraph 51, it's considering different alternatives, does it have a duty to then go out and disclose that, make that same disclosure to every other shareholder or risk insider trading? And every time a meeting occurs or an incremental alternative is discussed among board members, among officers, among people by email, if Mr. McGuire's theory is accepted, there would have to be an update to disclosures along the way. And this would create a completely unworkable approach that is contrary to settled securities law. And as a practical matter, companies and boards make decisions every day. And the law does not require a corporation to provide a continuing update from day to day, from hour to hour, every time an alternative is considered. The law is settled on this point, and if it were upended here, that would create uncertainty regarding the basic principles I mentioned at the outset. And so the practical effect, once more, of accepting Mr. McGuire's theory is that a statement by Ms. Austin in an email could be deemed adequate to bind the future decision-making of the board of directors as to a matter that the plan says they had sole discretion. And I think it bears pausing on that point for a moment. If we accept that theory, an email by Ms. Austin could tie the hands of the board and in effect be a guarantee and change a future decision of the board of directors. And that theory simply can't be squared with securities law, corporate law, or the laws of negligent misrepresentation. Now, I want to talk about each of these three claims separately, and I'm going to start with the claim where Justice Ervin left off just a moment ago. So I'm going to pivot to the ordinary negligence claim. And this is, again, it's important to look at the complaint itself, and that's paragraphs 42 and 43 and 44 and 45 on record page 12. And what is alleged here is, just as Justice Ervin mentioned, it is about a misrepresentation or omission, not about conduct. The allegation is that Ms. Austin had a duty to provide accurate information to the plaintiff, and that she should have known there was no, there's that word again, guarantee, and had a duty to tell him about that it was not guaranteed. This is addressed in detail in our brief, but as to Justice Ervin's question, the Oberlin Capital case is the one I would look to first. It is a case decided on a motion to dismiss. It is in connection with a negligent misrepresentation where the court focuses on the fact that a party has a duty to investigate matters himself and reasonably. And the court looked at first a negligent misrepresentation claim and dismissed the case on a motion to dismiss. And then the court turned to the negligence claim, which relied on exactly the same analysis. And the court analyzed the negligence claim under the same rubric as the negligent misrepresentation claim, because the court apparently concluded that if you're alleging that there's a negligent misrepresentation, whether you use the word negligent misrepresentation or not, if your conduct relates to a representation, then we have to treat it as it's alleged, treat the substance of it rather than what it is called. And I want to make this point with a broader comment about the nature of a negligent misrepresentation claim as a subspecies, if you will, of negligence. There are circumstances where an ordinary negligence claim may exist when a negligent misrepresentation claim does not, to be sure. But this case is not one of them. They include medical malpractice claims, wrongful death claims, premises liability, negligent supervision, and the like. And what they all have in common is a negligent act. Those cases also generally involve bodily injury as well, but for purposes here, negligent act. And a negligence claim is a claim where a negligent act is performed. A negligent misrepresentation claim is one where there is a negligent statement. And once more, when we tether ourselves to the complaint, as we must, we have to see, as I think Justice Ervin's question raised, that really what's at issue in this case is a negligent statement, not a negligent act. The reason why Mr. McGuire's position cannot be the law of North Carolina is that it would mean that we don't have such a thing as a negligent misrepresentation claim, because no one would ever assert one if ordinary negligence could be satisfied when it was a statement, because there are fewer elements. It's not required to be pleaded with particularity, and negligence on its own does not require reasonable reliance. And so it would essentially be a decision by this court to say, well, the elements of negligent misrepresentation don't apply. Now, I have relied heavily, and I'm going to move on, but I have relied heavily on the Oberlin Capital case, which admittedly is a Court of Appeals opinion. But I also wanted to mention that that opinion decision has been endorsed by this court, including in an opinion by Justice Newby in the Dallaire versus Bank of America case, a 2014 case, where the court basically adopted the reasoning and cited that case. So it's not simply relying on a 20-year-old Court of Appeals case. I believe this court has supported and endorsed that as well. I'm going to shift now to the Securities Act claim and talk about that one briefly. And again, the same principles apply here. Starting with first principles, in general, there is no duty to speak in connection with the purchase or sale of a security. This has long been the case under federal securities laws, and our courts have long followed the lead of the federal securities laws on this, including the U.S. Supreme Court. And frankly, that's what our North Carolina Business Court has been doing since Judge Tennille first came on the bench, and now Judge Bledsoe and Judge Robinson and Judge Gale and others. The second principle here is that when a plaintiff has access to the terms governing a securities transaction, he cannot bring a claim based on an alleged failure to remind him of those terms. And we've cited the Sullivan versus Mebane packaging case, a 2003 case. We've also cited Fourth Circuit authority that makes clear that a sophisticated investor is presumed to have read all the documents that relate to and govern the transaction. Mr. McGuire has admitted he is a sophisticated investor. He certainly was. He was director of Lord Corporation, Japan operations. But we don't even need that. We have a presumption, but we don't even need that presumption because, in fact, he was sophisticated. The third principle here, though, relates to the misrepresentation element. And this may sound familiar because this is a similar element to each of the other claims. And here there must be a false statement. And if we look at the language of the plan, it is clear that and again, the allegations of the complaint contemplate or treat the email statements as a guarantee by Ms. Austin. It is clear from looking at the language in the plan that there could, in fact, be no guarantee about the future. A guarantee could not have been a possible interpretation of the plan. In this case, Mr. McGuire's counsel has argued that there was an inference made in favor of Lord. Our position is it doesn't matter what inference is drawn, whether we draw that inference in favor of Mr. McGuire or we draw it in favor of Lord, the result is the same. Because if Mr. McGuire had read the plan, he would have seen that she could not guarantee the outcome. And this whole case, as I said earlier, unravels. So in short, Mr. McGuire is trying to say that this email statement by Ms. Austin was a guarantee that tied the future decision-making of the Comp Committee of Lord's Board of Directors on a matter where they had sole discretion. And such an interpretation was contrary to the plain meaning of the plan and would defy common sense and the way that corporations do business. So finally, I will turn to the negligent misrepresentation claim. And because these issues overlap, I will endeavor to be brief on this topic. But the elements include a material false statement and justifiable reliance on a false statement. Starting with the most basic point, and again, this sounds familiar because it's the same principle of law that applies in each of these three scenarios. There is no duty owed by one party to a contract to remind the other of the contract's express terms or to explain their legal significance. We've cited the Eastway Wrecker Service case and the International Harvester case for this, and there are many other cases as well. Our second basic point, and it's a very close corollary to the first point, is this. There can be no justifiable reliance where the plaintiff, quote, could have learned the true facts through reasonable diligence. And once more, we have to look at what the true facts are that are alleged to have been omitted. And as we looked at paragraphs 62 and 63 and 64 at the outset, we see that the allegations there, the omitted material fact, is what the plan clearly states to Mr. McGuire. There are other cases we've cited as well, including Boone Ford, which holds that reliance is unjustified as a matter of law where the alleged misrepresentation contradicted an express contract term. As a matter of law, there can be no reasonable reliance. Now, I want to respond very briefly to a comment by Mr. McGuire's counsel here about how it's the unusual case that involves a dismissal for reasonable reliance. Ordinarily, those are issues for the jury. And I want to mention this today. The cases we've talked about, Oberlin Capital, which was endorsed by this court in the Dallaire versus Bank of America case, Hudson Coal and Eastway Wrecker, which this court affirmed per curiam, and Raritan River, another opinion of this court, all were motion to dismiss cases. And what they all have in common was there was a document or an opportunity to investigate the matter and to determine what the omitted fact was. Thus, the conclusion here that Judge Bledsoe decided was logical. It followed settled precedent and was exactly right. If Mr. McGuire had simply read the plan, which he had in his possession, he would have seen that Ms. Austin could not, to use McGuire's words, guarantee that he could repurchase the shares. I want to mention just one more point in passing, just to make sure this is on the court's radar screen. I don't believe it's controverted here, but to be clear, the North Carolina law does not recognize a claim for negligent misrepresentation by omission. That's been the law of our state for a very long time. That claim simply does not exist. To the extent that the theory here is one of omission, it can't constitute negligent misrepresentation. The claim is negligent misrepresentation, not negligent omission. Before I conclude, I want to just mention one or two other cases and comments here. The Terry versus Terry case was brought up both in Mr. McGuire's brief and also in argument today. That is a case relating to Rule 9b particularity requirement. What is not cited in the briefs is the further point that the case goes on to say that Rule 9b cannot be satisfied by mere conclusory language. And Rule 9b is not just to provide notice, as that opinion recognizes. It's also because anytime you allege that a person or a company makes a false statement, commits a fraud, that is inherently injurious. And so conclusory allegations are insufficient. Our rules try to guard against cavalier or casual assertions of misrepresentation and fraud. And I guess our point here cited in our brief is that we've cited case law saying that if any time a party relies on information and belief allegations to support a fraud claim, that's deemed conclusory. And we've cited cases, including securities cases, to that effect in our brief. I won't dwell on it anymore. And so I'll turn now, unless the court has questions, to a very brief conclusion to say that if Mr. McGuire had read this contract, he would have known that Ms. Austin could not guarantee that the board would not exercise its discretion and amend the plan later. Whether we're looking at this in one of these three possible claims, the basic premise of the plaintiff's claim is unsound, contrary to North Carolina law, and we request today that Judge Bledsoe's decision be affirmed. Thank you.
Thank you, counsel. Rebuttal.
Thank you. So I just want to address a few points here this afternoon. First, we contend that this is not a case about reading the express terms of a contract. In fact, Mr. McGuire alleges that he did read the governing documents. Reading the governing documents says simply that the plan is subject to change at some point, at any point in the board's discretion. But the stock agreement itself contemplates that shareholders should go to the board for questions about the interpretation. So on record page 64, paragraph 11, that's the stock purchase agreement. That paragraph states, any question of fact necessary for the application of this agreement and any question of interpretation or application of this agreement shall be determined by the compensation committee of the board of directors. We allege that they delegated, of course, that duty to Ms. Austin. So Mr. McGuire did exactly what any reasonable investor would do. He read the plan documents and then went to the only person designated to answer questions about those documents. Second, Lord says that a reversal would change securities laws by creating sort of a heightened duty to inform shareholders about every single decision that a board makes. Here, though, Lord undertook to designate a special person to answer questions that its shareholders had about their stocks. It chose not just to have, for example, an FAQ page on its website. It had a designated person that served solely in that role. Third, while there are allegations about the language of the complaint of the plan and the complaint, Mr. McGuire also alleges that Ms. Austin failed to tell Mr. McGuire that the decision to terminate, suspend had already been made. At the end of the day, the court must, on a Rule 12b6 motion, construe all inferences in the light most favorable to Mr. McGuire. If the court assumes that the inference could be drawn that Mr. McGuire was asking about the status of the program, Mr. McGuire has stated claims for all three torts. And finally, I want to address just the point about the on information and belief paragraph. Allegations can be made on information and belief. It doesn't make the allegation conclusory. A conclusory allegation is one that lacks supporting facts. Here in paragraph 31 of the complaint, that's record page 10, Mr. McGuire alleges that he knew that the business was considering changes to its stock program. He alleged that Ms. Austin knew that Lord had in fact decided to suspend or terminate the program as of March 2nd, and he alleged that she knew that by virtue of her role as the liaison between the company and its owners. If the court has no further questions, thank you for your time today.
Thank you, counsel. Thank you, everyone. Madam Clerk.
Oh yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess until 9:30 tomorrow morning. God save the state and this honorable court.